May I please? Lordship, item number 13 in motion column, my lord. It is a hardly, my lord, 14-15 page petition. And my file is misplaced, my lord. Despite several efforts, my lord, I could not find out. I may be allowed to take a scan from the original, my lord.
No, not at all possible.
Or
You have
else,
to apply for, or you can talk with the registry. We
okay.
cannot give you a scan copy from the court itself. Registry can provide you.
So I will note the relevant pages from the record, my lord, and then I will submit before your court. I will.
You are noting down,
Yes, yes.
or you want to submit today.
Yes, yes. It's a motion hardly 14-15 pages, my lord.
No, whatever, you can.
Yes, yes.
But we are cannot provide you the scan.
Yes. Obliged.
May it please your lordship, item 31, the case diary has not been received. So may I please beg to mention this for a short date?
31.
CD not received.
Not received.
Not received.
Are you on interim there?
No.
No.
CD not received. It's a reminder. Yes, when can it be?
From Hailakandi, my lord, 9th, my lord. 9th of
9th of March. 9th of March.
Obliged.
May I please your lordship? I beg to mention for listing of a bail application for tomorrow.
No, tomorrow is tomorrow.
Yes.
No. Maybe by due to बहुत matters here. Partner matter. At best in on 25th. 25th next week.
Yeah, please. Item number 19 and 21 from the daily list, the bail hearing matter, my lord. In the both the case, my lord, series there, but my senior is out of station today, lordship. I pay for today accommodation.
19 and 20.
Yes, lordship. 20. Yes.
19 and 21.
Yes, lordship. Both the case, my lord, is both have
19 and 20.
Sir. That is here, lordship.
In both the matters we have received the case.
Yes.
Here.
In both the matter we are in. So, only for the-
The informant side is also there. Na?
yes, sir. I've taken
In item number 19.
Sorry.
You have taken
taken.
consult.
only for the day.
To the other side and consult for the petition. Wait for it. 19 or 21. একেলগে নিদিব। In both the matters, CD received.
And both the matter interim.
Mr. Sharma, Dilane PP submitted that CD received. CD be retained till next date of listing. Are you on interim?
Yes, lordship. In the bottom.
Interim be continued till next date of listing. If you are going to retain the case diary where it can be filed.
next week, my lord.
That case 27.
Lordship. Yeah, interim may be continued.
Yes,
Yes.
so interim will be continued.
Deeply obliged.
Take report.
May please, Your Lordship. Your Lordship previously on 17 had allowed listing of a bail application on 19. However, the matter has not come up today.
Just go and make an inquiry before the registry. I'm not supposed to give you listing.
Obliged.
May I please, Your Lordship? I'd like to mention for listing one criminal revision petition, Lordship. The next witness, the Lordship. I am for the respondent in this case.
Next Wednesday,
Next
25th. Oh,
Deeply obliged. Another, Your Lordship, mention for listing one criminal petition, Lordship. Passing of a charge sheet.
maybe on 26th. in that.
Deeply obliged.
Wait, please, your lordship. I beg for listing criminal revision petition, lordship. Lordship, next week, any date for listing?
27th.
Oblige,
Wait,
lordship.
please, your lordship. I beg to mention item number 15 of daily list, lordship.
1-5.
Yes, 15. Kindly pass over it for today and fix it on another date, lordship.
Yes, what is the position of 15? Not up. But whether they are on interim?
Interim.
Even interim. And the request be filed on a petition. But it is submitted by Mr. Sharma that CD received, but it is not an updated one. And accordingly, he read that CD may be returned by calling an updated one. Stop CD be returned accordingly. Call for a updated case diary. I will hereby directed. What is the case diary on or before the next date of listing?
16th.
This the matter accordingly on 16/3, so it's interim be continued till next date. your interim will be correct.
May I please your lordship, I beg to mention for listing of criminal revision petition, my lord.
Maybe on 27th.
My lord, for withdrawal, my lord. Tomorrow maybe, my lord.
Withdrawal is tomorrow.
Yes, my lord. Obliged.
Your lordship, it mention a bail application for listing your lordship on Monday, your lordship.
Monday may not be possible. May let it be on 25th. We are listing it. Because Monday many matters are there. Tuesday we have some part heard matters, so we cannot fix it. Let it be on Wednesday, that is on 25th. We are listing.
May I please your lordship, I beg to mention listing for a regular bail application.
Huh?
Regular bail application, lordship.
Regular bail application.
And fixed on
It will
Tuesday,
be listed on 26th. 26th of this next week.
lordship, it was left over the matter, lordship, last 6 to
No,
2020.
we are not in a position to say anything. It is on 26th. 26th.
May I please to your lordship, I beg to mention for listing a IA for withdrawal of money deposited by the petitioner. That's in criminal revision petition.
Money was deposited there.
Deposited by them. We are filing IA for withdrawal.
Okay, let it be on Monday.
Lordship, can it be on Friday?
Friday means tomorrow.
Monday. Obliged.
Please, my lord. One item has been listed before court number 21, which is not sitting today. And my lord, item number 586 of 23, criminal petition. Can it be taken up on 24th or 26th, my lord?
So just tell us the item number.
Item number 2, my lord.
Item number 2. What is the case number?
Criminal petition 586 of 23, my lord.
586
My lord.
of 23.
Any date, 24th or 26th of this month, my lord.
Maybe on 24th. We are
Right.
trying. We bring the record and pass the order.
Deeply obliged.
Before I give.
May it please your lordship. Lordship, humble prayer to withdraw the matter with the liberty to file fresh, lordship.
When you're seeking liberty, what is the ground for withdrawal?
Lordship,
Just
we
tell
have
us.
received few crucial documents which are yet to be submitted to the court, lordship.
Now see, if there are some documents you have now, it was not filed earlier, isn't it? So those documents can be filed through in your additional affidavit also. What is the reason for withdrawal? That one.
Lordship,
It can be filed. Can make a prayer before the court. It can be filed through an additional affidavit. It will be accepted.
lordship, it is the instruction of my senior, that's why, lordship.
No, sir. Now see, when you're seeking a liberty, there has to be some reason.
Lordship,
Why you seeking the liberty? Simple withdrawal is okay, but if you're seeking any liberty to file afresh, then there has to be some reasons. That's otherwise you call your senior. What I'm saying, you are saying that there are some documents, vital documents, where
we have
it
received.
could not be submitted. Court can grant you time. You can file it through your additional affidavit.
Lordship,
There
maybe
could be any
there are
reason
some
for withdrawal.
rectification also to be. There are some rectification also to be done to the documents.
What kind of
Lordship.
rectification is it in?
Lordship, I don't have the brief, lordship, but there are some rectification. Lordship.
Your MS?
Mayuri Bhuya, lordship.
So your counsel name is not here.
Lordship.
Your senior counsel's name is not here. It is
Not
only
here.
your
Yes,
name is
yes,
reflected.
lordship.
Huh?
Yes, lordship. It's
Then-
been done in my name.
Third MS M. Borva, the Lieutenant Counsel. It is submitted by her that as per instructions of the client, she wants to withdraw the same with a liberty to file a fresh. She further submitted that there are some vital documents which could not be annexed along with the petition, as well as there are some formal defects in the petition, and for which she wants to withdraw the same with a liberty to file fresh. They are allowed. Case is disposed of accordingly on withdrawal with a liberty to file afresh if so annexed.
Highly obliged, lordship.
Wait, please, hold on. It's not NDPS commercial quantity, my lord. Regular bail application. But these are those old cases, my lord, of 2024, my lord, where, my lord, the police at that point of time did not, my lord, comply with the requirements of Section 50 CRPC, as well as, my lord, they did not even, were not perhaps aware also, my lord. So this is also such type of case, my lord. The co-accused were already granted bail on that ground itself, my lord. If your lordship will kindly see page number 37. The co-accused, my lord, were granted bail on 5/5/2025 on the ground of non-compliance of, my lord, 47-48 of BNS. Now, the FIR is at page number 16.
My lord, it was charged case, my lord, lordship will verify, my lord. And from the record,
Let me submit, my lord. Let me submit.
reveals, my lord,
My lord, the allegation is this, that around 968 numbers of PAS plus tablets were allegedly recovered from the petitioner and one Firoz Ahmed, my lord. And the FIR was registered under 22C 29 NDPS. After that, my lord, the police started investigation, and if your lordship will kindly come to page number 22, this is the notice under 50. No grounds mentioned. Thereafter, my lord, police completed the investigation, my lord, and submitted charge sheet. And thereafter, my lord, trial started. And my instruction is that around 2 witnesses have been examined so far. And the petitioner, my lord, has completed 614 days in custody till date. But the only reason, my lord, why the petitioner could not move bail earlier, my lord, because these other accused, my lord, are all local persons. But the present petitioner, my lord, he hailed from Bihar. So he did not have any parents or any family members in Dhubri, my lord. That is why, my lord, he could not move any bail application earlier. But the other accused persons, my lord, they moved, and some of the accused persons also were granted bail. That is the case, my lord. Even LCR is called for, my lord, this will only come.
Yes, Sharma, do you want to say?
my submission is that, my lord, although some of the co-accused were granted bail, my lord, here it is the fresh case, my lord, today is for motion only, my lord. But you may call for report, my lord, trial for report will be required, my lord. And another important thing, my lord, his bail petition was rejected on 8/1/2026. Is 47.
By the Court of Special Judge.
These things have not been discussed, my lord, by the lower court regarding non-compliance of 50 and everything, my lord. No discussion.
They have submitted their point also there before or not, my lord. It is
Not required, my lord. It's mandate of law.
Okay, then where from it has to come?
Dhubri, my lord.
Dhubri.
Dhubri, in that case, how many? I mean,
7 days, man. One
10 days, my lord. 10 days.
in that case, when it can be?
Fine.
Next Thursday?
Fine. It will come to register,
No, whatever, because we are just asking.
my lord.
Next Thursday, paribo jana, ahi pabo. কম আছে নেকি মঙ্গলবাৰ কোৱা বৃহস্পতিবাৰ
25.
পাব লাগিব স্কেন কপি শুকুৰবাৰ 6 কৰি দিওঁ 26 scan copy of CRP copy distribute duly need with a you and the learned trial court below is also hereby directed to furnish the scan copy of the TCR along with the case diary on or before positively on or before the next
26. man.
dates.
Hello.
This is this matter which they had mentioned, my lord, regarding another item which was supposed to be tagged. Your lordship had allowed the mention, but that item did not get listed. Anyway, now,
Oh.
Anyway, my lord,
even if mediation is done in one case, it will suffice. Patrimonial dispute. So 498A and DV cases are there. And
Now,
there's
item number 3 is of 498A or DB?
item number 3 is only the DB case, my lord, and item number item number 3 is only DB case, and 4 is both DB and as well as the
498A.
498.
In
On a notice,
I think there is a stay order in respect of all the cases.
yes, sir. And notice was not issued in item number 3, but however, since the parties are ready to meditate, my lord, for the mediation, that matter will sent to mediation. We are hopeful that it might be settled. And apart from these cases, but there's also another case which we take together for mediation.
Actually, yesterday,
Yes, my lord, it
we
was
did a
not.
submission.
Yes, no.
But
Yes.
I don't know, it is not.
By in the order, your lordship may indicate that this matter may also be tagged along in these two similar matters.
Okay.
Already 3 and 4 are tagged.
No, I didn't. In that case, the other matter date is fixed on which? Is there any fixed date?
No fixed date.
No fixed.
No. If your lordship may indicate in today's order that along with these two matters, that matter also be
No,
taken
to
along.
court it has to go. That's why.
Then lordship may fix it on Tuesday also along with that matter.
Well, it can be your lordship, even if your lordship has an order for mediation in one case. It will suffice, my lord. Because the parties will eventually, though the father-in-law and other family members have also filed a quashing petition, at the end of the day, it is the husband and the wife who will have to settle. If they settle the dispute, my lord, all other disputes will get settled. So even if your lordship indicates it in one order, the parties can come together and they can at least make an attempt. Hereafter, if it does not,
that is okay. We are not. These two will go. These two cases will go. Now I'm saying that if the one matter and another matter is still pending, suppose it's not listed anywhere, you can
Actually, my lord,
make a
that's
mention.
important because that's where I filed the husband. I filed the petition there. No, sorry, my lord, that is the mother. Mother. But anyway, my learned friend is right, man. If these two may go for the mediation. If it's settled, then it can be also be indicated.
And in the meantime, you make a mention before the court by tomorrow itself for mentioning, so that the matter can come up by next Monday or Tuesday. It can be sent.
Yeah.
So in both 3 and 4,
My lord.
these are filed by you.
My lord.
And in both the matters, you are for the respondent.
Respondent number 2.
And state is 1. 3 and 4, acted honorary order by Mr. M. Smith, the learned counsel for the petition. Also heard Mr. S. Nawaz, the learned counsel, appearing for the respondent number 2, and Mr. P. Sharma, the learned counsel, appearing for the state respondent number 1. Mr. Smith as well as Mr. Nawaz, he submitted that both the parties are ready for amicable settlement, all the cases, and being the husband and wife, they are ready to appear before the mediation and to settle the matter for the mediation, court of mediation, before the mediator. As the parties are already been agreed to appear before the mediation, the registry is hereby directed to send both the case report before the mediation center, and the state legal services authority will also do the needful to appoint mediator. Appoint a mediator. When any date one we want.
Next week, any date, 10 days time.
Minimum 10-15 days will be required. 15 at a 12-15 din manner time.
5th or 6th of March, or 9th. 5th.
5th of March. 5th of March.
6th, like it's completed.
6th. Okay, 6th of March. And tomorrow you make a mention so that it can be listed by Monday or Tuesday. we can send it other case also.
Yes. Well, there's an
These two-
interim order money in item number 4, my lord, that can be noted.
Do you need still interim order?
Yes, my
my-
item number 4, my lord, but still, but if it doesn't suffer, if mediation is not successful, somehow that the proceedings are stayed, my lord, in item number 4, that the interim order.
Okay then. However, till the next date of listing, item number 4, the interim granted earlier will be continued. Okay.
But six is the date fixed before mediation or before this one.
As before mediation.
I'm declared.
So you will be appearing before mediation on 6th. সেইটো অলপমান বেলেগ কোৰ্টৰ অকণ বেলেগকে কৰি দিব দুটা ফুটা হওক বাইদেউ এটা ইণ্টাৰিম আছে দাম অলপমান বেলেগ yes item number 5 yes Mr. Ji yes
Please, Your Lordship.
yes
My Lord, my client is an advocate.
very nice
Yes. He was practicing in Gauhati, my Lord, about 20 years. So what happened, my Lord, he, along with his family, went to visit his original village, my Lord, at Bilashipara. Somehow, my Lord, there was some dispute arises between wife, children, and the advocate. And ultimately, my Lord, they seized the key of the car which belonged to the petitioner. They came to Gauhati with that car. So the petitioner left at Bilashipara. And after they returned to Gauhati, my Lord, they threatened me that you come to Gauhati, you will be desolation. So fearing my life, my Lord, I started my practice, shifted my practice at Bilashipara. And ultimately, my Lord, I have got house at Hatigaon. They occupied my house. They are living there with family, my wife and 2 children. And my books, my Lord, law books, journal, etc., my file is in their custody. My vehicle, that car, and one bike, my Lord, is in the forceful custody of them. So ultimately, my Lord, under this situation, my Lord, I file a complaint case against them. And in that case, my Lord, I pray that a search warrant may be issued to recover my car, my motorcycle, and the books of my profession may be handed over to me. Now, my Lord, after that case, my Lord, it was of 24. So, my Lord, here what happened, my Lord, there are 4 accused persons. 2 of my child, another children, and my wife and brother-in-law. Now what happened, my Lord? The learned court below, my Lord, passed the impugn order. That is at page 75, my Lord.
not 70 so it is not on 75
Now, my Lord,
where 75
76, your Lordship, after hearing the parties, last but one paragraph, page 76. After hearing the parties and perusal of case record, including the petition, page 76. Sixty-eight. 74 पेज में Hmm. 73, 74, 75, 74 आरंभ करून 74 petition है 70 मतलब और 70 लोग मिली ये तो की मतलब other matter may be taken maybe I mean, let me examine my let me examine the record my lord. Other matter may be taken.
Don't insert now any document. Don't insert in the file in any document at present.
Does not tally with my.
That's what I'm saying. It's not here.
Let me see where is the. Other matter may be taken. Let me.
I'm saying don't put the order now.
I'm not. I'm not. Number 6.
May I please your lordship?
Yes.
My lord, the petitioner lost an FIR, my lord, case 12 before the officer in charge of business police
Petitioner
station.
loves the FIR.
My lord,
The petitioner, present petitioner.
yes, my lord.
I say page number.
Case number 12 is the FIR filed by the present petitioner
Okay.
against the respondent number 2 in this criminal petition, my lord. Here, my lord, she stated that on 28/10/2024, my lord, the respondent number 2 took her to the temple and show the marriage was solemnized, and thereafter she was taken to the hotel and stayed the night in hotel, my lord. Thereafter, some days stayed in the relative's house, and my lord, on 3/11/2024, again, my lord, he took the present petitioner to the respondent number 2 sister's house, and that night also stayed there. And next day, that is 4/11/2024, he fled out. And thereafter, my lord, the petitioner tried to contact over telephone, and telephone received by other person, and that person will inform that the person is already die and you cannot contact second time. If you repeat, then I will kill you. And accordingly, my lord, the affair was registered under section, my lord, here is 13, section 64(1) and 351(3) of BNS. My lord, thereafter, the investigating agency completed the investigation and submitted charge sheet. Charge sheet is page, my lord, 18. Annexer B is the charge sheet. And in charge sheet, my lord, the investigating agency, page 22, well, lord, section 69 and 351(3) of BNSS, well, lord, the charge was shown. And one section is here, my lord, session tribunal. Therefore, the case was committed to the session court. And now, my lord, the
charge sheet
page
was put
24,
under which section?
well, lord, charge sheet is submitted under section
69.
69 and 351(3) of BNS. And my lord, impugn order is page 24, my 17/11/2025, the learned additional session judge Disney, my lord. And on the very first day, my lord, discharged the petition respondent number 2, my lord, from the cases, my lord. No section and no charges found here as per the learned court, my lord. So, my humble submission, my lord, those section rep and other section may not be present here, but it is very much clear, my lord, that section 81, earlier 943, earlier 943 of IPC, my lord. My lord, it is the
943.
case. My lord, the
943
material
was there.
clearly revealed that.
Whether 940, any 943 section is there.
My lord, the in charge sheet, my lord, that 81 BNS and earlier 493 IPC.
943 you are saying.
Yes, my lord, not present, but as per, my lord, the statement and the content of the FIR. This section is present, my lord. This section is that, my lord, that the accused deceitfully induced the petitioner to believe that she was lawfully married to him by performing a marriage ceremony in a temple and thereafter cohabited and established physical relationship with her. On that basis, and satisfied the ingredient of section 81 BNS and as well as 493 IPC. And another section also, my lord, may be present, my lord. Section 83, that is 496 IPC earlier. Here also, my lord, that record disclosed that the accused went through a marriage ceremony with the petitioner with dishonest and fraudulent intention and subsequently denied such marriage, thereby prima facie establishing that the accused knowingly went through a marriage ceremony which was not legally valid, attacking section 83 BNS. Page 7 by of my petition I have
No,
explained. my lord.
whatever now your convinced.
So I am, my lord, today, my lord, I am praying a notice may be issued, man. Upon the response number 2, my lord.
So you are agree with the order of discharge?
Yeah, discharge, man. And record also may be called for.
Mr. Anything? P. Sharma, the landed additional It's an application, section 438, read with section 442 PNSS, challenging the order of 17/11/2025 passed by learned in district and session judge Bijni in sessions case number 26, whereby respondent number 2 was discharged from the case from the case number 26, huh?
Yes, my
My
lord.
lord. Session case number 26 of
Yes, no, with this one.
26.
Yes. Submitted by Mr. Udi that in spite of privacy case against the respondent, the learned trial court, learned session judge had discharged the accused petitioner and without discharge the accused petitioner on the delay of hearing on charge. So notice to the respondents to speak and detailed process for formal notice required to be served. That is one number one. However, copy of the petition may be served during the course of the also call for the TCM list. Only sole accused was there, na?
Yes. No, my lord. The state also part.
No.
No, no,
They are
Yes,
little-
yes. Only soul, my lord.
List accordingly after 3 weeks as an individual. You take safe 2 days.
Yes. I am obliged.
Right. The matter regarding just come to not quash the matter, it's just come to interim order. One is non-bailable warrant issue, and another is lordship. Though both are juvenile, though it may be referred to juvenile court, not in general court. Lordship. It is my question is that lordship. Kindly see page 24, lordship. 24 issue NBW against the accused Kamrul Islam. He is aged 15 years by special court. It is a POSCO Act, lordship. But
By special court. As a case is
I
special
am
case.
humble.
Section 4.
But lordship, it may be go to jubilant court. It is not continuing. There is a clear law. No any.
No, law is obviously there. Now, where is the anything? What is on the what basis you are saying he is a juvenile? So this court is not supposed to make an inquiry regarding his juvenility. So at best we can send. Inquiry may be made by the learned trial court below, and then we'll submit the report. But as the petitioner is absconding, so how the inquiry will make? If you have some documents, you can submit, or if you,
Okay.
even if suppose document
I also
without his
submit one
presence, it
document.
cannot be.
His
Better
vaccination
to-
card is also there, Lordship.
Huh?
Vaccination card, Tika card.
Not do. Get a birth certificate or school certificate. Otherwise, certification test.
Hmm.
Last. So you will have to go through this.
He was a school going student at his child, I think.
He is a proper student. And
How can we
within
say
the age of 15 years, his father is already a stroke patient. I also anorexia.
now
And
see
due
your
to
petition?
starvation of his family, he go to Kerala, Bangalore, and doing their job small. That's why he dropped out. That school final certificate is not.
You have to write something. How can we now case?
I think vaccination card is very important because each and every
It
date is
may be
there.
important.
18, 11,
Yes, it is not important. Now, and your case, he was shown as an absconder in the charge sheet.
He's appealing now, but in that case,
No. He was shown as an absconder in the charge sheet.
Charge sheet or absconded.
ex-wonder. Ex-wonder, that's why he is in Bangalore, staying Bangalore.
No,
Police have not
page
charged.
number
Absconder charge sheet.
22. Kamrul absconded.
So he is the prime accused, right?
He is
Let's see.
the one. The girl is pregnant. So Lordship, we cannot say that he is minor or not. You have to produce this document. Either
He
by-
attained that capacity of procuring a child. In fact, I mean, giving, I think he was too mature at that time. Being a 14, 15
Now
years, I don't know, maybe nowadays everything is possible, but general presumption is a 14, 15-year boy may not be.
But in the time of offense,
But she is
minor.
already pregnant.
That's why the case may be continuing in minor court.
Whatever, how can we say he is a minor, major? How can we stay at this stage? Only for your vaccination card? It cannot be. And therefore, he is not present to go for an ossification test also. He is absconding. So how it can be possible? We have to make direction to the learned trial court below for making observation regarding his juvenility.
If he is
You are
juvenile,
taking
then
plea
they
of the
can appear and
juvenility.
produce the documents or give a petition that his observation test may be done.
You can approach the learned trial court
That's
below.
Yeah, then you'll have.
Finally, set aside my NBW.
How?
Non-bail of warrant is without summon, without any warrant of arrest, bailable warrant of arrest.
Now
Non-bailable
see,
warrant.
you are taking two pleas here. One plea is okay. His non-bailable warrant was issued. Now at the same time, you are taking that it has to be is to be sent before the so and so. So we are not in a position to take any steps as to why he is a juvenile, is a major. How can we say at this stage?
The question is that.
Or you have to amend your prayer now.
Also, let me be chance to file additional affidavit. That document is also another document if I.
We are not supposed to, I mean, judge your juvenility here in this case, court. It is not our duty. You have to record the statement. Doctors board has to be constituted. He has to go for medical, ossification test, etc. These are not supposed to do by this court. Huh?
We filed application and again, but they rejected. Again and again, we filed it for bail.
What filing again and again?
That court, trial court. So kindly set aside this order, Logic, 10/5/2002. Just NBW.
Make your prayer portion, change your prayer portion then. Because your prayer is definitely, your prayer is, immediate prayer is it to send the juvenile justice.
So limited, set aside
So
that and
how
pass
can
the
we
order
send
of
it
10/5/2002.
Juvenile Justice Board, how can we send here now? To send a case before the Juvenile Justice Board, there has to be something. Or at best we can make pass an order for inquiry, but inquiry also may not be possible. Your petition is absconding. How the learned trial court below will also conduct an inquiry? There is no possibility of making an inquiry because he is not appearing. to constitute a medical board to judge his, juvenility, etc., he has to go for an ossification test. For that only his presence will be required. Now, how can it be possible? Do one thing, your prayer is only for juvenile justice board and all. So,
There is two prayer, Lordship. One may be allowed. Just NBW
make sure you take correction.
Lordship, I am agreed to continue the case. I am not. It is false case.
One hand, you are saying you're
I am in
juvenile.
prayer. That time it was occurrence. That's why I am agreed to
File
continue.
an additional
Maybe
affidavit, your prayer portion amending your.
lastly it may be already false case. Maybe. But I can continue the trial. Just give me chance to.
Make your prayer corrected.
Also, there, Lordship, I have.
There is no first prayer is
Page-
to send it.
Page 10.
Just make a correction. Hard mecha A
Ten.
manipulate for time or A.H. Alamgir, Dilane Council for the petition.
In the premises
Use of
emphasized, it
the
is there
record, it is
most
seen that the
respectfully
prayer
prayer
portion
that your
is,
Lordship may be pleased to.
prayer portion needs some correction. In view of this, the learned counsel for the petitioner is hereby directed to furnish an additional affidavit by correcting public amending the prayer portion. List the matter accordingly after 1 week as on a date to be fixed. You make a correction.
May it please your Lordship.
Yes.
Also, this petition is referred against the judgment dated Lordship, concurrent judgment Lordship dated 29/10/2025. Against a criminal appeal Lordship. Number 19 of 2024 Lordship.
Notice must be full and I.
There was concurrent judgment Lordship convicting the accused person Lordship, the petitioner Lordship.
Appeal you have a next year?
Yes, Lordship. That is case 15 Lordship. 15 to 24, the operative portion is Lordship.
17.
This was upheld Lordship. The judgment of the lower court was upheld Lordship, trial court Lordship. Case 24 Lordship.
So now he is in custody or outside?
Lordship, he is in outside, but NBW is issued Lordship. I have filed a IA also in this regard for recalling the NBW.
The judgment was passed on 29th of October.
29/10 Lordship. Lordship, that 20% also has been deposited by the appellant, by the petitioner Lordship.
At the time of admitting the
in
appeal.
the time of appeal Lordship. That is reflected in page 19 Lordship.
Where is the order of issuance of NBW, etc.?
Lordship, that is in IA Lordship.
Okay, we'll see it.
IA Lordship. That
Mr. S. J. Sharma, the learned counsel. This is an application. It's for 38. Report for state is the formal party. State is the formal. Mr. Sorry, MS A. Bacon, the learned petitioner PP, appearing on behalf of state. Then petition under section 438. The 438 oblique 442, read with section 528 being sitting as said in Washington. The impugned judgment and order dated 29/10/2025. Passed by Learned Court of Additional Session Judge FTC Sagar, some in connection with criminal appeal number 18, Federal 4 of 2024, arising out of judgment and order dated 1909 passed by learned additional CGM in NI case number 87 of 2018 under section 138 of the issue notice to the respondents to speed post and visual process. No formal notice is required to be served on the state respond number 1. However, copy of the petition may be served during the course. Also called for the scan copy of the DCR. Also called for the DCR of appeal criminal appeal number 18-4 of the 2024 and NI case number 87 of the list matter of court session date. I to part in sermon also part typical the petition under section 528 BNS for recalling the order of dated 3/11/2025, whereby NBWA was issued by the Court of Additional CGM Sipsagar in connection with NI case number 87 of. And another prayer, do you have any other prayer? Only recalling of the order?
Lordship, in the main petition, I have the prayer for stay, Lordship. Page 12, Lordship.
Page
12, Lordship. During the pension pending of the case, the further be pleased to stay the operation of the impugned judgment and order dated.
Main case to considering this submission. Main case to applicant so and so. The stay of the operation of impugned judgment and order dated 19/10/2025 passed by additional session as FTC in tribunal appeal number 18/4/2020 arising out of order dated 1909 passed in NI case number 87. Restate till disposal of the present petition. Itu tahu so and so follow no. Time of petition of the appeal also, the petitioner had filed the 20% of the check amount, that is the 2 lakhs before the court. The bill was accordingly dismissed with the direction the petitioner could appear before the learned trial court bill. Before his appearance, the learned trial court bill had already issued the NBWA against present petitioner, and which he prayed for the recalling of the NBWA issued by the learned additional CGM Sipsagar in connection with NI case number 87/18 by order dated 3/11. You have ordered the application. During the submission made by land the order of issuance of NBWA dated 3/11/2025 passed by learned additional CGM Sipsagar in connection with NI case number 87 of is hereby state of suspended till the disposal of the connected petition. With the above observation, the present I stands
Obligation.
Yes, yes.
My lord, it may come on Monday, my lord, because in my copy, my lord, there is some, the documents was not properly arranged in my copy. In judge's copy, it is all right.
No, but this order is not there.
My lord, order is there, my lord, but I refer a certain page which is not available with me. So, my lord, there is some arrangement is not proper of my document in my office copy. So, my lord, it may be on Monday, my lord. There is
Customer
prayer for
produce.
interim order also.
Customer. Part Mr. M.A. Sheikh Dilani consulted petitioner, and it is submitted. There are some mismatch of the misarrangement of the documents in his file, and accordingly paid some more time to arrange his own file. In view of this, let the matter Monday may not be possible. You were on interim. Interim was there.
Yes, interim prayer is there one.
Interim. No, this has come for first time.
Yeah, first time, my lord.
Sir, how interim prayer?
Interim is necessary because, my
Oh
lord,
no, we cannot pass any. It- Wednesday, 24th.
24,
Oh, sorry, 25th.
25. Obligation.
My lord, money execution case is pending against me before the Honorable Civil Judge Junior Division against for enforcement of the judgment passed in the local adult regarding, my lord, NIF case, my lord. And thereafter, I was directed to file written objection. I prayed for filing objection, but on that day, my counsel could not file the objection, page 38. And therefore, my lord, writ has been issued and matter is fixed today before the learned court. And because of issuance of writ, my lord, I am not able to file the written objection. And in any case, my lord, I am ready to pay the amount since the matter has been settled amicably before the local adult. So my humble prayer would be that I may be allowed to file written objection, and as per local adult, I will pay the amount, my lord, on installment basis.
You are not paying.
Not paying, my lord, because of my. Yes, my lord. Then I was directed to file objection against the, my lord, against the my lord, page 34 onwards, my lord. Yes. 34, then money execution cases registered. Then page 36, filed petition showing the date for another date for filing wakalatnama. And page 37, another date for filing written objection. And the date was fixed on 3/2/2026, page 37. And on 3/2/2016, page 38, parties are represented, no written objection filed, issue writ. DH is directed to take steps for issuance of it. In view of that order, I may be given some opportunity, my lord, to file objection. And my lord, page 25 and 26, 8/3/2025. 25. Both are friends, both are cousin brothers, residing same village, my lord. Same area. In paragraph 9, I have stated that the petitioner is ready to pay the aforesaid amount in installment basis if the honorable court allows quotation.
pay the
Not paid, my lord. I have offered 40,000 of unofficially, but she refused to accept, and she wants the amount at once. Since I'm an unemployed, my lord, it's not possible for me to pay entire amount, and therefore I approached the private respondent to accept the amount on installment basis. Yes,
Now you are ready to pay.
yes, madam. In paragraph 9, I have stated, madam. Answer, ma'am.
The reason why you pay.
Madam, paragraph 5, I have stated that the petitioner, after aforesaid order, to communicate with the respondent complaint and willing to pay the whole amount in installment basis, and ultimately has offered some amount of rupees 40,000. But the respondent refused to accept this amount and asked to pay the whole amount as per Honorable Court's order. Due to financial hardship, the petitioner could not pay the said amount in time.
You want to file.
Yes.
File.
Yes, my lord.
Or you want to pay the money.
I am ready to pay money because of this issue of writ. I am unable to file objection as well as objection means there the petition respondent is also seeking some interest, and against that I am also going to file objection. Interest seeking interest. Yes, ma'am. Yes, not able. Case is pending, madam. Disposal. Yes.
Make this a lordship. The 528 application, my lord. And lordship, have a look at page 16, the FIR, my lord. May I read, my lord? I would like to inform you that myself, so and so, resident so and so, that sir, I have noticed a fact that one of the person of our village, namely Fulbar Ali, who resides in so and so place, and who is, per my information below, had married a young girl, namely so and so, who is, per my information, below the permissible age of marriage. I have personally inquired the age of the bride, and I have informed the age of the girl is below 18 years at the time of her marriage. Moreover, I have learned presently the victim girl is pregnant, and in this regard, I have also consulted with the local ASHA worker, namely so and so, my lord. Ultimately, he got arrested, my lord. Subsequently, he was enlarged on bail. And the police, my lord, investigating agency, after investigating the case, my lord, filed a charge sheet, my lord, in this case, my lord, and the POXO, my lord. My lord, filing the charge sheet, my lord, page 20 for your lordship of one, page 20, my lord. There are 4 list of witnesses, my lord. Number 1, my lord, he is the informant. Number 2, 2 and 3 are the mothers of the, my lord, these 2, boy and girl, my lord. And 4 is, my lord, IO, my lord. Now they are living as husband and wife, my lord. He is at presently 20 years, my lord. And the husband age is 22, my lord. Well, let notice go at this stage, my lord, to the informant, my lord. And I had a interim prayer, my lord. Can it maybe state, my lord, the proceeding? My lord, the next date is fixed on 13/3/2026 for evidence.
Notice of it.
I have also annexed the, my lord, 164 of the victim, my lord, page 25. At the time of marriage, she was 17 years.
Admitted to as in last we have the age spectrum.
I'm obliged, my lord, deeply obliged.
May I please, Lordship? At the Lordship, in this case, I filed this 528 application for passing of the FIR charge sheet and the entire proceeding of the GR case. Now, Lordship, in this case, Lordship, the speedy trial is the fundamental rights of the accused person, which is violated in this case. Lordship, this case is pending since 1995 to till now. And the Lordship, the FIR was lost in the year 1993, and the police filed a charge sheet in the year 1995. And the Lordship, the summon was issued to the accused person on 17/11/1995. But Lordship, thereafter, Lordship, the accused person they appeared before the trial court on the 28/8/1997. Lordship, in this case, there are the three accused persons. And the Lordship, other two accused persons, the Santosh Kumar and the Raj Kumar, the absconder charge sheet was filed against them. And they were not present at the time of the investigation, and the police could not arrest them. Thereafter, Lordship, the Santosh Kumar appeared before the trial court 22/1998. Thereafter, the Rajkumar was not present, so the learned court below was issued the PNA against him. Thereafter, Lordship, again, the process return answer on the 14/2/2007. And the Lordship, another accused, the Rajkumar was present on 7/4/2010. It is 7/4/2010. Yes, Lordship. But Lordship, thereafter, Lordship, the Santosh Kumar was not present, so the learned court below filed the case against him on the 29/8/2015. Yes, Lordship. And the Santosh Kumar was absent, so the case was filed and the case record was split up on the 29/8/2015. Thereafter, Lordship, the case was fixed for copy on the 29/10/2015. Lordship, kindly peruse the order 23, Annexure 23, page number 74. The Lordship, on that day, Lordship, the learned court below could not find out the case diary, and the copy could not be served to the accused person. Page number 74. Yes. Thereafter, Lordship, the case was again fixed on the 19/1/2016 for the case diary. But Lordship, Annexure 76. Again, Lordship, the copies could not trace out the case diary, so the copy was not served to the accused person. Again, Lordship, Thereafter, the learned court below called for the duplicate copy from the OC, the Jalukbari PS. But Lordship, and the report was submitted by the OC concerned the Jalukbari PS on the 1/6/2016, where the IO stated that the CD could not be traced out in the police station and in the officer in charge chamber. So Lordship, Annexer 26, page number 79. The report was submitted by the police, where it is stated that in the report, Lordship, the report was submitted by the SI. Stated that the CD could not be traced out at the PS, including officer in charge chamber. Thereafter, Lordship, the Rajkumar, the co-accused person, he was absent, so the learned court below issued an NBW, and the matter was split up again against the Rajkumar on the 27/9/2022. Thereafter, Lordship, the matter was again fixed for CD, and the IO was directed to personally appear before the learned court below. Then 22/6/2023, the OC concern was also directed to appear before the learned court. But Lordship, then the 22/9/2023, Annexer 31, the 87 page numbers. Lordship, the OC, there was a report submitted by the OC. It was mentioned that but the duplicate CD is not found in the PS. And the Lordship, the learned court below send the copy of the order to the DCP Crime Bureau Gauhati and the DGP, Director General of the Police. But the Lordship, the CD was not produced before the court till now. Thereafter, on the 22/9/2023, the learned court below has filed the case. Now, Lordship, this case is pending since 1995 because it was filed in 1995. And the Lordship, yes, Lordship. Lordship, kindly peruse the last order, Lordship, Annexer 31, page number 84. The case was filed because the CD could not produced by the IO. Lordship, Annexer 31, page number 87. Yes, Lordship. And Lordship, my name is Jugendranath Guwari. Your Honor, the case was filed against me also. Yes. No, Lordship, on the 22/9/2023, the case is filed against me also. 22/9/2023. Page number 8. No, page number 87. Page number 87, Annexer 31. So Lordship, this case, Lordship, the copy was not served to the accused person. Since 1995, this case is pending. And the Lordship, under section 207 of the CRPC, the furnishing of the copy is mandatory. And in this case, till now, the court, the learned court below has not committed the case to the session court because the statute was filed under section 302 of IPC, which is tribal by the session court. Now, Lordship, since 33 years, Lordship, this case is pending before the Chief Judicial Magistrate. And the Lordship, there is no possibility to end this case because Lordship, the case has been filed by the learned court below. And in the year 2023, now, Lordship, the present petitioner is the CRPF personnel. In the last year, he retired from his service. Now, Lordship, his pension benefit is pending, Lordship. Because Lordship, this case is still pending. For non-disposal of this case, the petitioner is suffering, Lordship. And the Lordship, my fundamental rights has been violated. And even Lordship, if the court perused the search sheet, Lordship, the investigating agency has not recorded, mentioned the address of the witnesses and the co-accused person. That's why Lordship, the case has been pending. Because Lordship, on many times, the learned court below has issued the NBW, which was not executed. Because Lordship, once Lordship, the report was given that Santosh Kumar was the resident of the Haryana. Thereafter, one report was submitted wherein it is stated that Santosh Kumar accused person that he was the resident of Uttar Pradesh. So Lordship, if the court continue the proceeding of this trial court, then lordship my fundamental rights will be violated, because the lordship speedy trial is my fundamental rights, and the DR has been, and the lordship did the inordinate delay due to the investigating agency. Yes.
All and get for your trial.
Yes.
Get it even
Yes. Yes, yes, lordship. Yes, lord. Yes. Yes. Yes, yes, lord. Yes. Yes. Yes, lord. Yes. Yes, lord. Yes.
Okay.
Yes. Yes. But lordship, in the FIR and the search lordship, the name of the deceased person is not a mention, lordship. Because lordship in the search sheet and the yes. 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 But lordship, yes, lordship, but it is okay, lordship, but because the case is filed. But lordship, I am hanging over because lordship, I retired from my service in the last year June, and the lordship, my service the benefit is pending because of for the non-disposal of this case. Now, lordship, I am 61 years old, because lordship, I have to survive, lordship, because I retired from my service, because the prosecution could not continue the case. So lordship, yes, lordship. But because lordship, there is no evidence that yes, lordship, I understand, lordship, but lordship, yes, yes, but lordship, how long, lordship, I will wait? Yes, but the lordship, the thing is that lordship, how long I will to wait for disposal of this case?
Notice advice what to say, Lord, because the last record also they have said that CD was not received. That is of page number 31.
Not only one occasion, many occasions.
By going to the SARC Lordship, they can arrange some reconstruct Lordship, because as there is no hope for getting back the city. Only if there is a way of getting something real against him. So the SARC, there are some in the
But lordship, the trial court tried to reconstruct the case diary, but there is no possibility for the reconstruction after 33 years. How is possible? Because the case diary is not available in the PS.
that is mentioned, Lord, the duplicate is not getting.
But lordship, done. Yes, 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 lordship. Yeah. Yes.
Yes, record.
But lordship, the learned court below it send the order of the copy and to the Director General of Police, to the DCP crime. The learned court below has given all the efforts for reconstruction of the case diary. But lordship, the learned court below has failed. That's why the learned court below filed this case. And the lordship,
Only that.
but lordship, from the record, lordship, it is very apparent that reconstruction is not possible, because learned court below they given the effort because there are order, lordship.
The charge sheet, their witnesses are there.
Lordship, kindly peruse the charge sheet. The name of the witnesses is given, but the address of the witnesses are not mentioned. And the lordship, the accused person, Santosh Kumar. Yes.
There is address, Lordship. Vishwanath Singh, care of so and so, Beltola. Some address are there. Lordship.
Okay, this is a dispute. But Lordship, the dispute was arises between the two armed forces of the central government. Lordship, this dispute was arises between the two armed forces of the central government. The present petitioner was the work posted at Dimapur, while he was transferred to the Chandigarh, and his unit was coming from the Dimapur to Rongya rail station. At that point of time, the Lordship, when they reached at the Saraighat overbridge, then Lordship, the army vehicle was behind his truck. Then Lordship, there is a dispute because the army personnel they given the signals and tried to overtake the CRPF vehicle. Then when, yes, CRPF Lordship. Obliged lordship.
in NIA case, and against the order of conviction, petitioner preferred a criminal revision. That criminal revision is pending before this court, my lord. Now, during pendency of the criminal revision, my lord, the learned trial court, my lord, issued NBW and PNA against the petitioner, my lord. Only against that order I have approached this court, my lord. Lordship will find the order of criminal revision, my lord, that criminal revision is pending before this court. That is page number 9, my lord. Stay is not there, but notice was issued, my lord, and the criminal revision is pending, my lord. And during pendency of the criminal revision, my lord, the learned court below, your lordship will find the order, my lord, starting from. Stay is not there, but criminal revision has been admitted and it is pending, my lord. And well, there is a possibility, and there is a possibility of settlement also, my lord, by humble. No, my lord, what is my submission, my lord? The NBW issued against the petition that may be stated, and the criminal revision pending before this court that may be referred to, my lord, in the ensuing, my lord, national local adalat, my lord, so that madam. Well, at this is, my lord, NBW may be stated, my lord. 311, 311, 2025, my lord. Until then, my lord, my lord, the police is searching me, and the petitioner is, my lord, is a railway employee, my lord, is a great for a railway employee. And here actually the case is. No, my lord, my lord, at least, my lord, till then, my lord, only the NBW order, that PN order issued by the learned trial court, that may be stated. Then, my lord, make a short day, my lord, 2nd of March.
The 520 application, my lord. As I have mentioned in the morning, my lord, I have misplaced the record. My lord, lordship may find the gist in page number 15 and 16. Page 15, Annexure 1. The complaint petition in an NI Act, my lord, case, my lord, pending before the learned additional CJM Morigao. My lord, yes, it's still pending a new case, my lord, in fact. Lordship may kindly go through the contents in page 15, my lord, the bottom paragraphs. This is the complaint, my lord. Paragraph 1 is complainant is so and so. Paragraph 2, my lord. The accused person is the registered owner of the Mahindra Bolero 4-wheeler. My lord, bearing registration number so and so, which is sold to the complainant on so and so, 24 January 2024, my lord. Date is important, my lord. 24 January 2024. And the accused has received the entire sold amount from the complainant by giving assurance to him to deliver the NOC of the said vehicle from the finance company within a month, my lord. At the time of purchasing, my lord, the complainant knew that there is a loan pending, my lord. Thereafter, my lord, the narration has been made that I made promise to return the amount to the finance company and such and such. Lordship may find at the bottom of that page, my lord. But lastly, my lord, bottom of the page. But lastly, the accused again gave assurance to return the amount in the month of January 2025. Has your lordship got it? Yes. And then on 27 to 25, the accused person have issued a check number so and so, that is so and so, only in favor of complainant drawn on Axis Bank Limited for the payment of the borrowed loan amount to the finance company for getting the NOC. The narration in the complaint itself shows, my lord, there was no legally recoverable debt towards the, my lord, complainant. Whatever the debt was towards the, my lord, finance company. Now, lordship may kindly turn to page 23, my lord. Page 22 first, my lord. Page 22 is the payment receipt, my lord. I have totally foreclosed the loan with the finance company. I have paid the I kept paying in installment from January, my lord, and then eventually in the month of December, my lord, I paid the entire amount to the finance company. Next page, my lord, page 23. Agreement status. It is closed. That means my loan has been closed. In page 23, my lord, in the left side, lordship will find the asset Bolero. The loan was against Bolero. And date of disbursal, disbursal of the loan was, it was before reselling. Therefore, no question arises that I have fraudulently taken the loan. First, I sold the vehicle and then taken the loan. The loan was existing on the date of selling, reselling, my lord. That I admit. And accordingly, I repaid the loan to the bank. My lord, what happened? After closure of the loan, my lord, loan account, I communicated to the complainant, saying that now you can close, withdraw the complaint. Because it is a INI proceeding, my lord, summary proceeding, only confined to the check. And check was not meant to him. He misused it. Then I submitted before the court, my lord, on the last date. Since he has paid out the loan, now they came to the stage of, my lord, blackmailing. Complainant want to say that he wants another 3 lakh as a consequential loss. Then I submitted to the landed, my lord, court below, whether under a proceeding under 138, consequential loss can be determined by the court, whether it is permissible. In my humble submission, no. Therefore, my lord, the loan amount was towards the bank, it has been paid out. So this case is, this NI proceeding is not at all maintainable at this stage, my lord. Whatever consequential damages he claims, my lord, he can go for a civil suit, my lord. If he has suffered from any consequential damages due to late payment by me to the finance company, he can approach to the civil court, my lord. And in fact, the, my lord, Lanet court below has issued an NBW against me, my lord, for my non-appearance in a particular date, my lord. Last occasion, my advocate appeared and presented all documents to the Lanet court below. And Lanet court below is also helpless because he was, complainant was present there. He is raising claim of 3 lakhs. So at this stage, my humble submission would be, my lord, this case is not maintainable in the present facts and circumstances. And the, my lord, lordship may issue notice until returnable date, my lord. The further proceeding may be stayed. And I have paid the interim price also there, man. Yes. No legally enforceable debt. Mas, final further proceeding, my lord. Much okay.
Lordship, in this matter, my lord, interim protection is granted. My lord, in last several occasions, FSL report was also called for. It was not placed, my lord. So, Lordship, my lord, under the facts of the case, but only out of doubt, FIR was lost that
Already interim lordship.
interim, my lord. So, interim may be absolute, my lord.
No lordship. Special need to be there.
Last 6 months.
Case there without FSL report, and moreover, the last date of the entry is lordship 26/6/2025. Lordship 36/2025. 30/06/2025. Thirty 30. 30.
Interim may be continued. Bless.
May it please your lordship. But, the affair is at page 8, my lord. Short affair, my lord. Affair is at page 8, my lord. With due respect, I beg to state that on Iman, at around 10:30 p.m., the two affair named accused persons came to my shop, namely Mass Steel Furniture, situated near Boroma Overbridge, by riding a white-colored two-wheeler vehicle, and in addition to hurling abuses at the employee of my shop, they also threatened to kill me and my employees and then left therefrom. Thereafter, around 1:20 a.m., one Kadwan Patwari, wife of late Hare Krishna Patwari, residing in the vicinity of my shop at Boroma PS, Boroma district, Baksa, who informed me over mobile phone number Iman that my shop had caught fire and that a white colored four-wheeler vehicle was parked in front of my shop. I immediately came to my shop and found that goods worth rupees 2 lakh got destroyed in the fire, and I called the police station and informed about the incident. I over phone called my employees and asked them to come out from the shop, and when they came out from the shop, the vehicle left from the front of my shop at a very high speed. Therefore, your good self may look into the matter and take appropriate action. So, the only thing is the white color four-wheeler, and nothing else. And your lordship has granted interim bail, my lord. He is on bail since 2/9/2025. Nothing else, my lord. That only this four-wheeler was parked in front of the.
It is not that lordship, only only the identification of the car is there. Before the incident in the FIR, it stated that they come and threaten this person, and after that they went away. And one the persons who are the employees of the shop, lordship, they have also seen. But the thing is that lordship, after the interim was granted, they threatened lordship. It is there. So IO has made a prayer for cancellation of that interim lordship. It is there. And the CDR of the accused person is also there. He called this one of the witness lordship. It is there in the CD lordship.
Well, I do not know the allegation was how far it is true, my lord. Whom they, but the accused has threatened. Only one witness, that is the lady.
Moreover, materials are also there, Lord. And one of the, I have also flagged everything. One of the, another person is there who happens to be a witness lordship. He earlier also do this type of thing to that person, not this person, not this. Earlier same type of thing has also done. It is there, I have flagged my everything, Lord. The last one, Lord, last time. Let's see there, Lord, yellow color. Up, the top. I will not, sir.
My lord. Nitul.
He also along with this also. One witness has been suspended.
ওই দেখার পর তাই
Granted with the privilege of the next paper, Mr. Das, when an additional PP submitted in this regard, that there are sufficient incriminating materials against the present petition, and it is not a case that only the car was identified in some person, but the present petitioner along with some others were duly identified by some of the employees and witnesses of this case who also gave their statements. Mr. Das further submitted that he, after obtaining the order of pre-arrest bail, of interim order of interim pre-arrest bail, the accused petitioner is now threatening the witnesses not to depose against him or to change the statement of him which they have earlier stated before the eye, otherwise with dire consequences. Some severe analysis is also recorded, is also available in the case diary, where from also it is seen that he made some phone calls and threatened the witnesses to change their statement and not to say anything against him. They further submitted that I also filed his bail objection, stating that the petitioner is still threatening the witnesses, and which will hamper and tamper with the further investigation of this case if his pre-arrest bail is considered. Mr. Das accordingly raised payment objection and submitted that it is not at all the case to extend the privilege of pre-arrest bail to the present petition stage. Hearing this submission made by learning counsel for cases, I have also perused the case record and the sorry case diary and the annexures by learning. It is a admitted position that after obtaining the order of interim pre-arrest bail, the petitioner appeared before the IO and his statement is also recorded. However, from the materials available in the case diary, it is seen that there are sufficient materials against the present petitioner and he is also previously involved in such type of offenses and earlier also threatened present informant. That apart, it is also seen that obtaining the order of interim bail, now he is threatening the witnesses which violates his bail conditions. Thus, it is seen that the accused petitioner is not abide by bail conditions and that he is not cooperating with the IO. That apart, he is threatening the witnesses which will hamper and tamper with the evidences. Investigation of this case. In view of this, I find that the petitioner is not entitled with the privilege of pre-arrest bail, and hence the earlier interim bail order granted to the present petitioner dated 2/9/2025 is hereby stands vacated and the prayer for pre-arrest bail is accordingly received. Your petition stands rejected. Your earlier interim bail prayer is vacated at this stage. You're not supposed to threaten the witnesses.
I do not know, my lord, what is there in the case diary, my lord. No.
Giving with a white color vehicle, this is not the case only white color vehicle. He now threatening the witnesses.
They
Change
say, my
your
lord,
statement.
they say, my lord, I am threatening, my lord. I can.
No, yes, the material. He is now threatening the witnesses that change your statement, otherwise I will kill you. This kind of things are there. Over telephone also, over what to do. Okay.
In this case, my lord, the allegation is that some persons formed railway union and fraudulently collected money from the member or on the pretext of providing job. The allegation against the petitioner are that they are the executive. My lord, I am.
Before starting notes, here in this case, the petitioner was allowed to go on interim protection, but he is still late. He is not appearing in the. His statement is not available. Whether he is appear or not. 18 lords. I think. Two petitioners are there.
2152 was earlier disposed of.
Earlier disposed.
2152. Earlier disposed of.
And in one case, that was a BA.
Pardon?
That was regular verification.
AB.
Earlier, that 2720. One is a 2720. That was BA.
Oh, we have received only the case record of AB 215.
In item 18 or so?
Yes, we are on item 18.
In item we have CD.
No, in item 18, definitely. In item 18, 2492. It's a case record of 2492.
492.
Item 18 in otherwise 2492.
2492.
Along with 2492. I don't know why. There may be some reason. AB 2152 is also addressed out there. That is disposed of. There may be some reason why it was called for.
Earlier 2152 is disposed of.
2152 is disposed.
2152 is.
Order 9.
And it's question 2152 order.
152. So,
yes, Lordship, as his statement is not available in the CD. আমাকে একটা কেস করছে
itu বেলেগ
বেলেগ
কেইবাটাও কেছ হৈছে এইখন বহুত কেছ
In item 18, the 2492, as he said,
I don't know, maybe some reason, but there is no any mention. It is along with this one disposed of. I don't, but there is no mention at all. The order there is no mention that it has to be tagged along with this so and so. But anyway, this is of same accused.
same accused.
For the same accused or what? Your accused name is?
Biswajit Sriki and Purna Boro. Purna Bodole.
Oh no, it is not the case of Biswajit. It is Jitendra. Disposed of matter is Jitendra.
And there are one or two accused. Jitendra is the lordship. One accused is this.
Oh, one accused is Jitendra.
Why it is declared also?
There are many cases against them.
There are many accused persons. Jitendra is another one of the accused persons.
Jitendra is?
It is why it is declared.
Now, here before us, the two petitioners are one is Biswajit and one is Purna Bodole.
And they have been allowed to go on interim protective bail, but they did not appear. But as per the city, their statements are not available in the city, and there is no any column regarding their appearance for the IO.
Well, I have no instruction to that, my lord. So far the affair is concerned, my lord, only it has been alleged that we are the executive of the committee. Nothing else, my lord. That I will.
If order has been given, if a direction has been given to the IO, to the accused persons or petitioners to appear before the IO, and they do not appear, and it is the violation of the.
Yes, within 7 days you were asked to appear. No, do you have any instruction whether they have appeared or not?
Today I have no instruction, my lord.
Because one more order is there. Same submission was, I think, there from the additional PP from the prosecution. On 12/11/2025, same order is there. However, he submitted there is nothing to indicate as to whether the petitions appear before the investigating officer. So in that regard, any again the updated case diary was called for, and petition, but for what reasons their statements were not recorded. I always directly to record their statements.
Series updated.
On 18/11, another order is there. They went there, but their statements were not recorded. That is one order. So I was directed to record the statement within 7 days, and we were appeared directed to appear. But till now there is no statement.
The lordship has found that I appeared, but the statement was not recorded.
No, I have not found. It is your submission.
Oh.
This is not the observation of the court is not there.
My lord, allow me some time, my lord.
Last opportunity may be given if they do not appear in this time, and I will also take instruction from the IO whether they went there or whether if they went, their statements may be recorded. I also take with the
or do one thing. If it is already recorded, we'll make a direction to the IO to send your statement. And if it is suppose not available, then you just appear within 7 days to record your statement because these are not available. I mean, you may be right. They may appear. I don't know, but there is nothing before us that whether they have appeared or not. One number Uthar. Mr. KKD, the line not Mr. Yes, the body edition. It is submitted by Mr. Rockford that CD is available, but the statement of these two petitions are not available in the case diary. Case diary. So it is submitted by Mr. Day that as per his instructions, they have already appeared for the IO. Their statements were also recorded. In view of this, let updated case diary be called for from the concerned IO and with a further direction to furnish the statement of the witnesses, a statement of the petitioners if already recorded, and further it is in and the The petitioners are also further directed to appear before the IO within 7 days of the date of order. If they have not appeared before the IO or if their statements were earlier not recorded, let the matter be accordingly listed in the 10th of March, so and so, calling an update list. Interim be continued till next. We are continuing your interim till next date of listing.
My lord.
Just take the instructions
My
as to
lord.
whether they
My
have
lord.
appeared. If not appeared, just ask him.
My-
It's submitted also.
Yes, in 20, what is the position? That's submitted. You were on interim? No. You were not
No
on
interim, my lord.
You are Mr.
M.U. Ahmed in lord.
Part Mr. M.U. Ahmed, Lieutenant Counsel. Part Mr. P.S. Case was fit for the case diary, but it is submitted by Mr. Lawford and a CS has already been submitted by CS number, yes.
35/26, dated 11 to 26.
As the case has already been charged, the petitioner is hereby directed to appear before the learned trial court below with an appropriate application which with the above observed present. What is the position in 20? They were in interim, I think.
I have gone to the case diary, Lordship. The PM report is there, but date, cause of death could not be ascertained, Lordship. Opinion regarding cause of death has been kept pending till the receipt of the chemical and toxicological analysis report from the FS. And Lordship, but in the, regarding the statements of witnesses, Lordship, they have, Lordship, my parents, that they have said that there was an altercation, as Lordship, the Dipanjali, Lordship.
I am Ashik Ahmed, not
Dipanjali,
Dipanjali.
you are for?
Ashik Ahmed.
He is the boyfriend of this Dipanjali, Lordship, the other petition. And Dipanjali was earlier, Lordship, with a relation with the deceased. As he had made another relation, Lordship, there was a quarrel, Lordship. And according to the witnesses, he hanged himself.
Quarrel between Dipanjali and these persons, not us.
The Asik, then he also assaulted. There was a fight with Asik, Lordship, because Asik was an employee of the office where Panjali was also.
Dipanjali ran the business. Like,
For that, Lordship, the parents, one or two witnesses, same. Cause of death is not certain. Earlier, she was in relation with the deceased.
Where's the PM report?
PM report is there. I have tagged up.
But the PM report says any
There is litigation work is there.
in the earlier page.
I have ticked. Accuser also assaulted him, and then they went to their home. Then next day,
Yes, what is your submission? Otherwise, these accused was also present.
Lordship, he was present, Lordship. I think you assaulted him. So there is a ligature mark, Lordship, but cause of death has not been assigned. Opinion,
Okay, then wait for.
I am an interim.
You are Mr.
I am an interim.
No, your good name?
Zat Rahman.
Huh?
Zat Rahman.
Jed Rahman. Mr. Jed Rahman. That FS report is updated and then the cause of death is not till date. Cause of death is not ascertained till date. In period it's submitted that the report may be this the case diary be returned back. Have the direction to furnish the updated case diary along with the SL, which has the opinion of that cause. It's the matter when it released the matter on 9/3. Till that the interim be continued.
Hello.
My lord, in 23, my lord, I am the girl, my lord, the Dipanjali Medi, my lord. But I am not an interim, my lord. So I prayed, my lord, my interim may be considered, my lord. In last occasion, my lord, it was not considered. Now, my lord, case diary before your lordship, my lord. That boy, my lord, who committed suicide, my lord. It is in the affair itself, my lord. My lord, he always, my lord, disturbed the girl, my lord. When, my lord, there is some altercation, that boy, Ashik Ahmed, my lord, he assaulted that boy, my lord. And in the night, my lord, that boy committed suicide, my lord. But I am the lady before girl before your lordship, my lord.
So
But he always disturbed
you are the
that.
culprit for
My,
his
my lord,
you are the main culprit.
my lord, he repeatedly, my lord, disturbed the petitioner, my lord, the girl, my lord.
City updated case with part assembly of the petition. আগৰ খিনি city receipt the city return so and so forth 90. The listing it on 90. Somehow you managed till 90.
It's very unfortunate, my lord, he committed suicide. And my kindly see the role of the girl, my lord.
That's what I'm
that
saying.
boy, my lord,
He is the
disturbed the
main-
girl, my
main
lord.
issue.
See the main.
He is the main issue.
Obliged, my lord. Date, my lord.
90, same date, 90.
9/3. Obliged.
No case, sir. No case has been registered against that.
So against you, there is no case.
No.
Okay. You are Mr.
A Kashyap on behalf
Are
of
Mr.
T Medi.
A. Kashyap, done it once, appearing on behalf of Mr. D. Mehdi. Also, MSK with done it additional PPA payment status. Report received from which police station it is? Nunmati. Nunmati police station, Gauhati, wherein it is reported that no case has been registered against the present petition till date. In view of this, the present petition is accordingly disposed of. However, the petitioner is at liberty to approach any forum, any proper forum, if in the event of registering a case against him with the above the what kind of report you have received?
Lordship. With reference to
report.
Nunmati.
Nunmati.
25.
Report be kept with the case record.
Lordship, similar item 25.
25 also. No? But you're appealing for same person because
Stage.
Okay, then same order. No case has been registered. So you are at liberty to approach the court in the event if any case is registered.
Obliged, Lord.
May I please, Your
The
Lordship?
position here. Sit it.
Because in fact, there is no case against me. I am the
No.
driver of a oil tanker, Lordship. I was driving the oil tanker from Gauhati to Misamari.
and police suspected that I was stealing some oil from the oil tanker while it was being parked. And thereafter, they have taken it in their custody and it has been measured. And it is found that the quantity of the oil was accurate, Lordship. So there is no case in fact, but police is looking after me.
And suspected that you have.
Yes, Lordship. FI is in
You have
case number
told
9.
some.
Yes, Lordship.
He is also they were from the place of occurrence when the police person came to the place. Therefore, he was suspected.
In page number 15, Lordship.
You are the driver.
Yes, Lordship. But in page number 15, Lordship will find a certificate issued by the Indian Oil Corporation Limited officers. It was when it was measured, Lordship, in presence of Jyoti Moidas and Gautam Mondal and Mitu Das of police, Misamari Test and the officials of the Oil India Corporation Limited. It was shown that
No short.
there is no shortage, Lordship. In fact, he has not said away, Lordship. After parking the vehicle, he was not there. But police, without any knowledge of him, how they have carried the vehicle to the police station and seized thereafter. He has no knowledge, Lordship. Thereafter, Lordship, police has been looking for him to arrest him. I'm ready to appear before the IO, Lordship, as and when I may be called for, Lordship.
Mr. K. Did you receive? Is submitted by Mr. K. In fact, there is no case against him. He was only suspected of stealing the oil from the tank. In presence of witnesses, the tank and there were no shortage of sale. The is submitted that no cases, there is no case against the petitioner. However, he is ready and willing to extend his cooperation if same is needed by the IO during the investigation. Mr. Sharma, the learned edition will be submitted in this that from the note of the IO and for the material submitted in the case diary. It is seen there at the time of at the time when the vehicle was seized. He was absconding, but later on it was found that there is no shortage of there is no shortage of oil at the time of measurement, and it is and the oil was found as per the invoices. There was it is reported by the IO that there is no deficiency of oil in the tank, which was seized in connection. Next, bank submission made by the and overall all other aspects of the case and the custodial interrogation of the present petitioner may not be required for the investigation. However, the petition is hereby directed condition but oh, you will be under. Into DAD into him.
Here CD received by.
Map the color.
My lord, as per allegation, this petitioner, my lord, tried to, my lord, blackmail the, my lord,
Police personnel, my lord.
police personnel, my lord.
Yes.
But as per my instruction, my lord, the actual case is different, my lord. This police personnel, when, my lord, dealing some, my lord, bribery, my lord, video, my lord, footage was taken, my lord. And apprehending that, my lord, in future, this video footage may be used against him, my lord. In anticipation, my lord, he lodged this FIR. In fact, my lord, there is no record or any WhatsApp, my lord, messages, etc., is not sent by the petitioner, my lord.
You are
Nevertheless,
saying that police personnel went to for robbery.
no, my lord, bribery, my lord.
Oh, bribery.
Bribery, my lord. He said, my lord, favorable police report would be given for, my lord, passport purpose, my lord. It was discussed, my lord. Nevertheless, my lord, notice was issued, my lord, under section, my lord, 35(3) of BNS, my lord, page 14, my lord. As per this notice, my lord, arrest is not necessary. But petitioner is, my lord, apprehending that, my lord, as the matter is, my lord, regarding police, my lord, he may be misguided, my lord. His notice at page 14, my lord, annexed 2, my lord. Otherwise, my lord, it is mere, my lord, attempt as per allegation.
Where is the FIR?
My lord, FIR, my lord, page 12, my lord.
Yes.
And notice, my lord, page 14, my
See
lord.
the case there, my lord. Here, what happened, my lord? He has prepared some edited, my lord, more video, my lord. And it was sent to the, my lord, complaint that is police officer, my lord, and demanded rupees 6 lakh rupees. And just WhatsApp, my lord, and said that, also said that if it is not given, my lord, he will send the video to the, my lord, social media and other platform, my lord, of causing serious damage to the complaint, my lord. And thereafter, his interim anticipatory bill was rejected by the court below, my lord, and thereafter 35 notice was given, my lord. But he is not cooperating with the investigation, my lord. And from the witnesses and statement of the, my lord, he revealed that he is the person, my lord. Both of them went to the station and thereafter edited. My submission is it is not a case, my lord, it case to grant anticipated.
My
court below rightly rejected their prayer, my lord.
My instruction is that, my lord, there is nothing as such happened, my lord, but it is only allegation made, my lord, in anticipation that perhaps they may use this video against them, my lord. Therefore, they also issued notice, my lord, 35(3) of BNS, my lord. Prima facie at this stage, my lord, please.
Presentation Rolson after loss. He edited.
Yes. Is there? Can he be give a chance for recording this tape? Maybe it may not be a fit case otherwise. But obviously, rightly 35(3) was.
Well, that is also already over, my lord. 35 notice was given earlier, my lord. I have 2 times he was given 35 notice, my lord.
No, lord,
But he did not appear.
1/2/2026. That is already over, my lord. If they have received the notice, my lord, then they have to come before the court, my lord, earlier, my lord. But it was today is, my lord, 19th, my lord. Before on 1/2, my lord. That was given on 1/2/2020. There's a bail objection from the IO.
Under he can appear.
Yeah.
He can appear.
When arrest is not necessary as per petition.
This is not the
Okay, yes, where
Yeah,
it is
yeah,
not
sorry.
there are the provision that 35(3) is to be issued.
Yeah.
That is only the option. The aim for
My objection needed, sir. My objection needed.
aim for being different. But distribution. It's an application section submitted by Mr. Bob, representing this petitioner as innocent, and it is a, in fact, the police officials was asking bribe for giving the verification required for the passport, and on their objection only this false and concocted allegation has been brought against the present petition. However, the police also issued 35(3) notices against the present petitioner, but as there is an apprehension of arrest, he could not appear before the IO. But he is ready and willing to extend his cooperation in the further investigation if he is provided with some information. Next paragraph. Mr. Sharma, the learned additional PP, raised objection and submitted that from the case diary, it is seen that this is the person who tried to blackmail the police personnel with a threatening that they would make viral some videos which were they were created, which and those videos were created by edited video, and those edited videos were edited photograph and videos were decorated oblique edited video was where will be make will be make viral if he is and yes that stuff backfilling this way and so showing some edited video and also threaten that those videos and photographs will be will made viral if they is not fulfill their demand. However, it is a fact that 35(3) notices were issued to the present petitioner in view of this. This court is of opinion that an interim protection may be provided to the present petitioner so that he can appear before the IO and can record his statement and also can cooperate in the investigation. Interim PD. He will be under interim, appear before the IO.
Hello.
10(3), we're listing it on 10(3), appear
Mal-
before
Mal-
witness.
Up to date city, man.
Yes, up to date city.
10-3.
Diploma.
Yes, Mr. Mahmood, do you have one order? Na? In order column, you have one matter.
Yes,
There is one I is also there.
I
I
is
is
also
for suspension.
I for bail.
Yes, sir,
I have
suspension.
joined the bus with 540 days.
Here we have verified, man. Perhaps they have not taken steps, man.
No, no, no.
Oh,
You are asked to notice was served upon you.
it's a
Then
POCSO matter.
it
Well,
was
there is
sent.
no any order.
Okay, we'll see.
Actually, they were asked to verify whether notice is served or not.
14, Your Lordship, of the daily list.
14 means is an admission.
Criminal petition, Your Lordship, in admission, Your
It may not be taken up. That's why
Lordship.
we want any.
So may I
Both,
pray
both
for
the parties are present here.
Lordship?
In that case, do you want any preferable date here?
Lordship, 6th of March, your lordship, if your lordship please.
Friday. It can be on 6th of March then.
6th of March.
Yes, okay.
Much obliged.
6th of March. Sixth of March.
But item 28, my learned friend has taken information. Notice has gone, but it is applicable. On lordship, another date will be given. It will be served. Lordship.
It is already served.
Not served, lordship, because the police station is Modigaon and the person is in the Janji Road. Lordship. So, but I have communicated to him within these days, lordship, he will serve. Maybe fixed on 24, lord.
This week, 24 next week.
Otherwise, any
Some
date-
part matters are there.
otherwise, lordship, any date, lordship convenient.
26 within.
Lord.
Heard Mr. M. Mahmood and
I'm in jail since 540 days.
and also heard
That is also a concern.
Das, the learned edition PP appearing on the state respondent. It is submitted by Mr. Das that as per his instruction, this notice could not be served to the respondent number 2 till date as earlier. However, it is assured by the concerned
24
police station
Diana,
that may be served within 2
24
days.
Diana.
In view of this, let the matter be listed on 26/2/2025. I criminal law. Okay, then we're listing it on 26.
29.
May I please, but today it's for CD, my lord.
It is not available.
Now this I is
I
in
have for
connection with
correction of
AB.
post
Why?
correction of post title, my lord. This
Oh,
may be dispose of, my lord. Correction.
already you have filed.
Yes. I'm on a
Okay.
team, my lord.
Right, the class.
So 123, that's it. All right.
Let's go. 120.
08.
What kind of correction was you required? In fact,
My lord, sections, my lord. Nagaon PS
section.
case number.
Then where is the correction?
Correction 126. It should be 126 2 1172 3085 and 3 subsequent 5.
No, yes, that is your IA.
Correct.
So, where you have submitted that you have already corrected? From where? It is already corrected or not yet?
No, it is corrected. I have filed.
IA was still pending. On what basis you have filed another IA? I don't know.
No, my lord, it's only the I. There is no I, my lord.
One IA lordship is saying one IA where he has for correction of 126. It is pending, lord. IA is pending for correction of
I
the
may be
section,
dispose of, my lord. Maybe dispose of.
No, you have already filed that you have filed one corrected IA.
No.
Yeah, this is for correction.
This is for
I
correction,
understand. That's why I'm just we are searching for.
yes.
Where is it? Oh, it is allowed.
It can be, lord.
Heard, Mr.
Yeah, my lord.
M. Ahmed, the Learned Counsel for the petition. AMH, the Learned Counsel for the petition. Also heard, Mr. Das, the Learned Edition PP, appearing on behalf of state. This interlocutory application has been filed for correction of the cause title as there is some mistakes while filing the connected AB. Sections division. time of filing, so there is some wrong mention. There is some mistakes in mentioning the sections under which the case is raised. Pre-comma, accordingly, he submitted that the connected cause title of the connected AP needs to be corrected obliquely. Mr. Das, the learned edition PP, raised no objection considering the submission made by learned counsel for process. This I is allowed with a direction to file amended public corrected post title in connected AB. Number AB to given number AB 3025 of it. AB2 was released recently. Equal to people. Now, at present, we don't have the corrected this amended petition, but however, we will pass an order here. Here, AB2 Teleco, hard MS, Mr. A. Ahmed, so Mr. Dekeda, so and so. It is submitted by Mr. Das, CD not received. For interim be continued till next date of listing. In the meantime, the petitioner will also file the corrected oblique modified post title in present application. List matter when it can be decided. 19 1 19 19 so and so interim be continued till next. In the meantime, you made the petition.
Public.
Just tell us the recent development now.
Well, we made an attempt, but it is not working out. Maybe at a later stage, may so happen between the brothers, people. I believe, my lord, if my learned friend agrees, then it can be. But my idea is, no, actually, what has happened, my lord, as I see, my lord, the direction that has been issued, it is somewhat, my lord, it contradicts.
Inconsistent.
That there is a problem. The Amin Commissioner has filed his report, but the direction itself seems to be contradicts the between the two directions. That is at page 50. If your lordship just goes to it once.
Yes, page 50.
Page 50, third line. Accordingly, a decree is passed declaring that the plaintiff has got right title and interest and possession over C2C land. Further, a permanent injunction is issued restraining a defendant and his agents, workmen, servant, etc. from dispossessing the plaintiff and or interfering in the peaceful possession of the land and houses by the plaintiff after partition and delivery of possession, demarcation of land. A preliminary decree is passed for division of Schedule A property into 2 equal shares, and it is further declared that the Circle Officer Dolgaon Revenue Circle is appointed as the Amin Commission to cause partition and to put the plaintiff in separate possession of his share. The suit is decreed without contest. Your lordship will kindly note the first direction was accordingly a decree is passed declaring that the plaintiff has got right title, interest, and possession over Schedule C land. So that part was already given to the plaintiff, and thereafter again, my lord, a preliminary decree is passed for division of Schedule A property into 2 equal shares.
Yes, on the last provision, you have submitted that.
Yes, we made an attempt.
No,
yes, my lord, there
because
is third.
B plus C is equal to A.
Yes, A is equal to B plus.
A is equal to B plus C. Then
C is already given to the plaintiff.
And again it is said that the entire scheduled land, that is A scheduled land, should be 2. Equal. So it will again create problem.
And lordship, just one more thing I want to add in furtherance to the same argument. Actually, the prayer was in alternative. One is declaration of C, and the consequential relief was that in C nobody can disturb us. So some restraining order, injunction, permanent injunction. That was one. And in the alternative, or was there, or a division of A schedule. So both alternative prayers. Normally, alternative, what we understand, lordship, that if the first prayer fails, then alternative will be.
Obviously, yes.
Here, both alternatives are granted.
So your alternative prayer was one was to.
Their alternative prayer, they were the plaintiffs.
Sorry, their alternative prayer was one was to.
For
The C schedule land
declaration
in
of our C
entirety.
schedule.
C schedule land in entirety.
Entirety. And consequential relief was that permanent injunction so that we cannot disturb. That was consequential.
And the other relief?
Alternative was or that or this preliminary decree which is given, granted here, that the entire A schedule should be divided. So that was the alternative. So here, both the alternative prayers are granted.
The prayers are at page 15.
No?
Yes.
Yes, 15.
In 15, before Roman 4, Lordship can see or. After, from Roman 4 onwards, this is the alternative.
Yes.
So here, the earlier prayer, first prayer is also granted, alternative is also granted. So that also cannot be, Your Honor. So that is my another submission. Of course, it was an ex parte decree. After WS, we could not contest. But at least the Honorable Learned Court should have seen at least this basic things.
So,
Yes, Usami, any other. So you want to submit that matter should be remanded back? Or what other?
that prayer is from them. Man.
That exactly on record cannot be agreed. I leave to your Lordship.
Because, my lord, that in the alternative, my lord, they say A into 2 equal shares. I agree to this, provided my residences are in CC. That, along with this, that CC land, where my residences are. So that part and equal half of A schedule, that is acceptable to me. Not the C schedule land in entirety, where my residences are, that particular that.
That part should be saved.
That part should be saved, and then this and A property should be divided into 2, and then either party gets.
That can be one way of looking at it. The photo is at page 18. The picture of the both the schedule. Page 18 is the picture. Lordship has got page 16, but page 18, sorry, page 18. Yes. So here, Lordship will see the C schedule land. It is both side of this diagonal road. Page 18, photo to us, not paint or here. C schedule, between this C schedule, one road is passing.
Yes.
And they have shown the shops. As I have said, there is a marketplace. C schedule is a relatively valuable land, which is our stand, for which we are asking for. And B schedule is also here in this picture. This dark number 161 and 162 down below. So this is agricultural land. And this is a market, and they have also shown the market because they have shown the shops.
Yes.
So that is the only thing that valuation difference is there.
C schedule land is of dark number 162.
C is of 185,
186.
Sorry,
186, 187, then 191, 190, all this.
All this.
Both side of the diagonal road.
Yes.
And from many sides, this land has actually got benefit because of road from various directions. That is why only we are saying that it should be equal. Of course, that kind of observation can be there, that if wherever they have made their Assam type residence, that much should be given in considering the proportional, because valuation is also seen by Commissioner. What is the value? Not only exactly the amount of land, not the quantity of land, even valuation is seen. So if that kind of a thing is given, they are saying that they are agreeable if their house is saved. House is saved, and saving that C schedule is divided.
I'm just making it my junior melon.
No, sir. The question is that your case got declared ex parte. I mean, you're against you. It is an ex parte.
Yes, yes.
So obviously, as per the ex parte decree, court observed whatever court observation was there.
Yes.
So prayer as per C schedule was given to the plaintiff.
Yes.
Is an enter. But alternative prayer was decided. So if the case as a whole, the decree may not be an executive decree.
Yes, yes, yes.
That is the main reason. Now,
Yes.
but the simple observation can be made by this court, but that too, while there may be again, maybe if their dispute arises again, while this demarcation of the equal shares and all. In that case, because you are brothers, so in that case, something has to be done, either from this side, or whatever. As you are the brothers, so some consideration can be.
My instruction is that there is a third part. That is why this is not coming well.
I have
Only
also
from the family, madam, but then other than these two brothers.
My instruction is also like that, they have complete faith in the court. They say that whatever the court does, we are okay, win, lose, or whatever, because it's not happy. They've tried also. It is not that they have not tried.
For everyone. Enough land. Maybe one shop will go this side, the other shop will come.
Only yes, only that much will happen.
As it is, this land is given by the eldest
Yes,
one
yes.
to the
Both of them, both are co-partners.
younger brother. They are co-partners. Now, even if the brothers are agreeable to some sort of arrangement, there is a third party who is creating a little bit. My lord, if your lordship comes to page 18 once.
18.
Yes, madam.
Yes.
190 and 191 to put this. It 191. Or 190. Huh? It is C schedule. It will like a tell B schedule to command go over. B schedule to kundu. B schedule एक ही नहीं है. B schedule here. My instruction is that in C schedule 191 and 190, 190 and 191.
190 and 191.
Yes, madam. These two drugs can be left to the plaintiff, my lord. Other than that, equal share. B schedule equal share, and C schedule also, if something is left, then that can be equal share. Only because 191 and 192, I have 190, man. I have my house, my residential house. Of course, it is subject to the defendants.
See, while matter may be remanded with a observation and direction. But while passing the order of suppose preliminary decree also for this equally share of this A schedule land, in that case also all the observations should be maybe problem, because but yes, the circle officer who will be there
whole field
They,
verification will be there. Field verification can be there.
Field verification will be there.
Yes.
We may make an observation in that regard also, that 190 and 191.
Yes.
But then what will be the remaining amount? We don't know at this stage.
That is why exactly to say that amount also without field verification, that is again for me also it is difficult to agree, because from the photo itself it seems that on the right side, that is 190, 191, there is more quantity of land, and secondly that means more than 1 bigha. So when I said that residence is to be saved, more than 1 bigha to be saved, it is like almost partitioning it here only. Because
No, but there are other lands, man. All these Daksar, it's a huge plot of land. 176 is a big plot of area. 176, even bigger than 190 or 191.
So,
total 7 bigha. It's total 7 bigha and odd.
In C there is 2 bigha.
Can you come in that case? Suppose, can you come to an before the at the time of field verification? You can come to an, in that case we can pass an order that the matter may be demanded back, preliminary decree may be accordingly paid by equal share or whatever equation, because that in that case it will be an executable decree. Now at the time of this demarcation and all, there again dispute. So in that period of time, if there is an amicable settlement between you, let's suppose residence is given to you, that part
so far as only residence is concerned, that kind of observation can be there. So far as only but here residence along with all shops, it has come, it seems, from this photo. I have never visited myself, but from this photo it seems that residence along with all shops and everything is this side.
Is there any provision? Suppose B schedule will be two shares.
Yes, that is 2 equal, no problem in that.
C schedule, if 2 equal share is there, suppose your shops and one of some establishment, can it be saved in that way?
It can be saved in that.
If the party agrees, my lord, this can be done, my lord. 190 and 190 is given to me because 190 my investment is there. The shops were constructed by me. That is one of the reasons why I am insisting on that land. My lord, this is not just plain land. I have constructed the houses there. So it has to come to me. I invested. Baki kini remaining land, my lord, that can be. And that is by no means my not lesser than my land, man. Your lordship, this
It may not be lesser than you, but as from his side.
And these lands are on both sides of the road. But anyway, they have to agree to it.
My lord, let there be field verification.
But land is also roadside land, or it is entirely agricultural.
Roadside land, they have to construct the houses. That's all.
It is entirely agricultural. Of course, there is a village road. One side there is a village road.
After the construction of the road, it is no longer agricultural on the road. It has become commercial places.
161 and 162, that is it. And the whole dispute is regarding difference in valuation. So, and if there is no difference in valuation, why are we actually fighting for? There is nothing other than that. Only the difference in valuation. Land I have also got, he has also got. We are co-partners here, there. Their basis is that there was a verbal partition. Our thing is that when they started constructing a shop and all, we gave a police case against them. That police case, that thing is not here because we did not file a plaint. When their title, they said, become clouded, then they filed declaratory title suit. The declaration that as on the basis of verbal agreement, this should be declared in my favor. So now if there is a field, because even for boundary wall disputes, lordship, even in title suits for boundary wall dispute in Gauhati, field verifications are done. Even for boundary wall, 3 feet here, 3 feet there, even for that, why there cannot be a field verification? And then
the Amin Commissioner did exactly that.
Yes.
What else did he do? This is the report you have seen.
No, I have seen the report. I have heard the report. The council on the other side has read. The problem is that how the Amin Commission, the interpretation given by Amin Commissioner because of this inconsistent decree. The judgment says that C belongs to declared totally in their favor. So C is untouchable. Now, because another thing is that A should be divided equally. Now, what they have done, what Amin Commissioner's interpretation, that is SDO Dolgao's interpretation, is that C is there. So out of 7 bigha, that is 2 bigha, 2 katha, something like that. So he has carved out another portion from B schedule and given in their favor. So that is even more loss or even more than what they asked for, more than their prayer. Can more than prayer be granted? So many judgments are there. If I'm not trying to go into that kind of controversy, but beyond prayer, commissioner is granting. Their prayer is give C schedule to us as per verbal agreement. Now, commissioner is going beyond, giving part of B schedule land also this side, because he's simply going by the number, and he is also not totally wrong, because from the
But he
judgment
has
is
carried
confusing.
out the direction, whatever was issued by
Yeah,
the learned court
actually,
below.
that
There is
also,
nothing- But he did physical verification. He did it. There was a point of time where he should have cooperated, didn't do it. Now we are saying from our side that if 190 and 191 of C schedule is safe for us, rest can be divided 50-50. That is all I am saying. That can be done under 151 power. Your lordship can pass a direction to that effect. Otherwise, it has to go down. We cannot take, my lord, either you challenge this or you come to a compromise. And in compromise, you must understand my rights also. You were given an opportunity, you didn't take it. You filed a written statement and chosen to keep silent. You never cross-examined my witnesses. And now quite a length of time has elapsed. You must also understand my side of the view. I have made investments here. I have developed this land.
That is not with my
And we are
cognitions.
making concessions. Why not? All right, since we have constructed and the rest of the land, you take C schedule, and other than that, B schedule PPP.
The only
And
thing
this
is,
is exactly what we wanted to, my lord, convey to my clients or my learned friend, my lord. But then there is a third party who is interfering. That is the problem.
Okay, and in that case,
now,
But
lordship, the thing is, even if we did not file WS, then also courts only on the basis of plain and the witness has to pass a reasoned order. Your lordship,
that's what that is also submitted by Mr. Goswami.
yes,
That the decree, there is a defect in passing the decree or order of the
Yeah.
court because two prayers have been granted, C schedule as well as the alternative prayer. That is, he also agreed to that.
No,
It is not
lordship,
a
then
case.
I totally leave upon your lordship. Actually, because without instruction or support from my client that this they are going to leave, for me as a counsel, I cannot make any concession. That is the thing, because their client is giving some instruction, they can say that, okay, for 190 and this. But whether I can make concession without proper, they are not giving instruction on, they say that whatever happens, because amicable thing is not happening. So they are totally reliant on lordships.
But now, see, in that case, see, the order is defective, decree is defective. That is admitted,
Yeah.
admitted position. But the question is that you never appeared, you never contest the case. So
Yeah.
they are saying that they are exclusive, they are under the position of the C schedule land, and that has already been given by the court. So now you are more inconvenient position because the decree is already in their favor. So why don't you come to a settlement? Before, not before this court, before this learned trial court also, while passing at the time of the, after if the case is remanded back, suppose, in that case, the court will have to pass an order. So
Lordship, what will
if you have
happen in
some
the future, I can.
settlement or your
May happen.
observation, we can record your observation. But if you insisted on that, maybe there, then I don't know. Again, it will be
No,
maybe a
lordship,
problem.
in future, it may be, because I cannot say what it cannot be, that there may not be settlement. I cannot say that also. But as on to them, I have to say what is my instruction, because they have a lot of time has passed since the matter was part heard, and they have tried. Tried means some common ground is not coming. Common ground where they can agree. So therefore,
So as per you, what are the common ground? Do you want to say anything in that regard?
common ground as per valuation, it is so far as what they say is that if their residence is there, so residence cannot be more than 1 bigha of land or 1 bigha of land. 1 bigha of
The
land is about
scheduled land comprises of how many? What is the quantity of land? In
2 bigha 2 katha 17 lessa. So
2
if
bigha 2 katha
17 lessa,
scheduled land.
C schedule land.
Then obviously more than 1 bigha they will have
No,
their share will be there.
No,
And your share
of
will be
course.
1 bigha.
Otherwise, also they will get more than 1 bigha. They will get. The only thing is, because exactly the
No, in one hand you are saying that the entire share scheduled land
Yes.
is more or less commercial land. That means
Yes.
it's the roadside land.
Roadside land.
Or the beachfront land is, to some extent, it may be considered as agricultural land, or value is less than.
Yes. Yes.
So if C schedule is entered, C schedule is suppose demarcated or divided between you,
Yes.
then obviously his residence and some of the shopkeeper will be his position. In rest, you take
Yes.
one
Yes.
bigha. So what is your position if it is
No,
equally
there
divided?
is no problem. Of course, they will get a lot number of shops. They will get their residence also. That concession, definitely. Residents, we don't want to, because our brother, should we cannot throw them out of the, not necessary. The only thing is whether exactly this 190 and 191 dark will be mentioned in the judgment, that exactly this belongs to them, with no further uh, on the field, with no further variation or latitude in the field. That is my only thing. That exactly I'm not
No,
able.
see,
Of course,
at
some
this stage
shops they
for
will
this
get.
court, it is not, we cannot make such an observation
Yes.
here. But obviously, if the matter is remanded back, then you can place your thing so that the circle officer or the officer who will be there in the for demarcation or the field verification, that observation may be made.
All right.
We will, to some extent, will make here observation, some kind of observation.
Yes.
These are the things. But after the remanding of the case, the matter again it will arise. Some questions will be there.
Yes.
So in that case, the order of the court may be specific to that effect, and then you can get the chance. Yes, Mr. Goswami, if you get the suppose 1 bigha, because C schedule is, as you have told it is comprising of 2 bigha, some kathas.
2 bigha, 2 katha.
17 less. 2
Two
katha,
bigha.
17 less.
So then both the parties will get more than 1 bigha.
More than 1 bigha, yes.
So in 1 bigha land, your residence and some shops will not be there, or what?
I
It
think
will
so,
be
my
state.
exactly that dark wise, my lord. It is mentioned in the schedule. 190 dark number, it contains 1 bigha 11 lesser of land. 190. And 191 1 katha 5 lesser. So that will come to 20 lesser is 1 katha. So slightly less than, my lord, 1 bigha 2 katha, possibly. Right? 1 bigha 0 katha 11 lesser. 0 lesser. Are we lesser? 11 আছে 16 lesser. 16 lesser.
Then, Lordship, I'm just taking 1 minute. Just can I be excused? I'll just call up my client. Because if that can solve forever the issue.
So where was the commissioner's report in that page?
That is not there in the record.
Oh, you have submitted that.
Last
page of
these are certified copy.
Joabar decision niki dekha.
I think I had given one copy.
Most probably, I don't know. Was it?
Has your lordship got it?
No, we just look site.
There, here, here, here. Copy name.
That is আগতে দিয়া সেইদিনাখন last
Zero katha আৰু
right?
total land আছে কিমান? দুই বিঘা 2 katha 17 আছে।
As per this report, C schedule land is this
2 bigha 2 kata 7.
2 kata 7 lessons is entire land was given to you, I think. Na?
Entire land is given to me. I am saying, my lord, that if these 2 drugs are given to me, out of this land, 1 bigha 1 kata 16 lassa will come to me, and rest will about the same.
Yes, yes. What is it? What amount? 190 and 191.
190 and 191. That together, my lord, figures out to be 1 bigha 1 kata 16.
Actually, we do 1 bigha 1 cut 1 that's
1 bigha 1 kata.
1 that's
One bigha, 1 kata.
That will leave 1 bigha 1 kata 1 lessa in C schedule land for the defendants.
1 kata. 1 bigha, 1 kata. How many less?
1 lessa for the defendants.
In that case, you will get a lesser quantity of.
I'll get 15 lessa more.
15 lesser, not 15 lesser more.
Huh?
Because it will comprises 2 bigha, 2 kata, 17 lessers.
Yes.
Out of 2 bigha, 2 kata, 17 lesser, if you get 1 bigha, 1 kata, 1 lesser, then you will get.
No, I get 1 bigha 1 kata 16 lessa.
Oh, 1 bigha, 1 kata, 16.
And they get 1 bigha 1 kata 1 lessa.
Achha, 1 bigha, 1 kata, 1 lesser.
I get 14 lessas more. 15 lessas.
So,
or in that case, in B schedule land, that may be
Equal.
Have you understood?
Yes.
If they get 190 and 191 dark, suppose
yes,
in that case they will be getting 1 bigha 1 kata 16 less.
yes.
Whereas you will get 1 bigha 1 kata 1 less.
Okay. A little less.
Little less.
Yes.
40 lessers less.
Yes. মই কৈ ফচি নহয়
Civil case, na?
It's not a case that even if 190 and 191, suppose we are not deciding
Yes,
here,
yes.
it will be observation will be made.
Yes.
In that case also, definitely he will get 15 lessers more.
That 15 lessa can also be divided into half. I can get 7 lessa.
Now, Lordship, what
Yes, even 15 lesser can be divided.
over telephone, what I have got the instruction, because telephonic is that also now Lordship has to save me to some extent. Because telephonic I'm they say that okay, they are ready for this, but then C schedule length should be equally divided. It's not that some adjustment.
Equally divided only.
Adjustment should not be made from B schedule. For this, whatever I mean, plus minus happens.
B schedule is.
He is talking about
No, B
C
schedule will 50-50 will happen, of course. And in C schedule also, because these shops and all these things, this is not in as per our thing is that not as per our connivance or our permission. These shops and all these things. So even then, telephonically they said that it can be given to them. Telephonically they are agreeable. But only thing is this, for example, whatever is less, it should be exactly equal. Whatever is less, they can, it is not that 190 and 191 exactly should be given to them. If we get something from 190, 191 also, maybe 2-3 shops, whatever. If that becomes exactly 50-50, then telephonically they are okay.
In that case, my lord, my friend can brought something in writing from his client.
And if that way, if the matter we cannot keep as a partner, we'll decide we pass the order.
One opportunity. Otherwise, it will again, my lord, unnecessarily, my lord, cause delay.
Because
one opportunity, your
making a
kindly
case
get-
partner
my lord,
is
what
really
has
problematic
fallen
for
from
us
my
also.
friends.
Now, Lordship, then I would say that Lordship will take a call. My clients are with whatever comes from Lordship, trying to accept. They're ready to accept.
Then your lordship can dispose of this matter.
Lordship will
On this
dispose.
line, we are making this concession.
No, what do you say? Take a call means?
No, the call means, I mean, a judgment, whatever judgment will be passed. My clients are agreeable. Of course, they will have to, and they are agreeable. They will be obliged.
Judgment on consensus.
yes, judgment will be on consciousness because keeping a matter
Yes, yes.
for them part heard it because I have also
My lord,
Yes.
my lord, there are some
adjourned some of the matters.
Yes.
So
No, we also want to end this because it has been a long pending.
now see, it will be basically the order most probably
Yes.
will be that this as you are agreeable, and from the it is agreeable that the decree which has been passed is a defective one and
Yes.
cannot be executed. It's
Yes.
not
Yes.
executable.
Yes.
However, considering your submission and all, we may
Yes.
pass an order.
Yes.
We may remand back the order for passing an decree with a correct decree, whatever the decree will be there, and in that case, some observation will be made from your submission, what you
Yes,
have
yes,
submitted today.
yes.
That observation will be made, and in with the observation, will make a direction to the learned trial court below, dispose of the matter on
Right.
demand.
Right.
So in that case, category violence, those things may be reflected in the order, so that it may be easier for the court also to pass anything.
All right.
Now, otherwise also, as I'm saying,
Yes.
Mr. Goswami is saying that 190, 191, suppose.
Yes.
So if I say that 190, 191, it is 190, 1 bigha, 1 katha, and say 16 lesser.
16 less.
Then in that case, he is getting 15 lessers more.
Yes.
But now Goswami is saying that even 15 lessers can be also divided.
Then very
Otherwise-
well. What else to say?
Now, if 15 lessers also can be divided, so that it will equal division will be there.
Yes.
Some
Yes.
in that case, yes, anything to say?
My lord, just 1 minute.
Sorry, can you tackle
Let us find out.
No, no. What I'm saying,
I
I
want
mean,
that
he may
my
take
lord,
instruction.
this dispute should come to an end.
Whatever instruction he may say, I don't know. But now the question is that if you get the 190, 191, maybe a little less of 190 and 191, most probably your shops and residents will be there only. It will be covered.
99% it will
But
be saved.
obviously, maybe, I don't know, one shop or 1.5 shop or 2 shop, maybe in their part. If it is divided, the 70 lissa is divided in equal.
Yes.
Because 1 bigha 1 katha is in your part, and 1 bigha 1 katha will be in his part. Remaining 70 lessas may be divided.
Yes.
So in that case, they may
My
get,
client is agreeable
they
to that.
may get one or
Very
two shop or whatever.
Just one phone call, my lord. Right now, I'll
এইখিনিত নৰখাব আৰু
কোনখিনি?
এই অকমান হাত লৈছে
সেইটোতো ময়ে দিলো কনচেপ্টখন।
No, it is yes, it is.
It is
some.
me.
It is
We
you.
insisting that this dispute comes to an end.
sir.
My
Yes,
lord,
yes,
we can
obviously,
live on
I do
this.
agree. I do agree, Mr. Goswami.
If it goes down, we can live on this for some months or years. Man. Let us not do it.
Yes, and these are between the brothers also.
Yes,
That is
yes.
also one.
They come to each other house also. After this last time for amicable settlement, they are not coming. Otherwise, they come to each other's house.
Things like this happen, not only in this case.
ঘৰত আহাটো এইকেইদিন ধৰি অলপ এভইড কৰি চলি আছে।
This landed property is very thing, na? It creates very lots of problem between the family members itself. Whenever you see any land dispute, any civil matters are there, maximum between the parties, between the Sacha Mama or whatever, or even the brothers and sisters.
You have to have a different attitude, my lord, to purchase land and to maintain that land. It's not possible nowadays. When people have become busy, they have got other activities to do. There was a time, my lord, when authorities would come and keep this 50 bighas. I'll see what has to be done. I'm giving it 50. They will mutate. There was a time when there was nothing else to do except to watch your land and grow food. Nowadays, nobody can, and people are not so enthusiastic about buying land. Instead, they will go buy a flat or a shop. They will not buy land and construct. No point.
No point.
At the end of it, all this will fizzle out. So it's better to, keep up your children well and all those things.
Yes. And sometimes it happens. Some people are still there who spend suppose more than 50, 60 lakhs for constructing the land only for giving for rent purpose.
Right.
Giving for the rent.
For rental.
So when for the rent he will get maximum say 15, 20, 30,000 even. That 30,000 for 50, 60 lakhs, when it will be covered up? For me, for your purpose, your self residence is okay.
Yes, ma'am.
You may spend, but for the purpose of giving rent and all, it's useless. When you will get 50, 60 lakhs of rupees if you spend, that is there only.
Well, this is the ultimate. Well, land is okay, madam. 7.5 or 7 lakhs. They will give that extra, but without shop on it. Because shop, madam, he has constructed by himself. That is the reason, nothing else.
But now see, Mr. Kusami,
Yes, Mr. Huh? Yes, I have also no idea. He also doesn't have any.
now see, Mr. Kusami, what I'm saying, cases, you also know better, he also,
Yes.
me also know that cases decrease defective one. So if it goes for remand back, we may made some observation, then definitely it will be a preliminary decree or decree, I mean, in equal shares of the A schedule land. In that case, if you don't make such an observation here itself, then definitely it will be equally shared. So in that case, you may be rather much loser, because how can you say that shop establishment will be there or not? In your petition, when you dark, suppose 190 and 191 covers your residence also, I think.
190, 191 covers my residence.
Your residence, and now you have said that 190 and 191, suppose it covers 1 bigha, 1 katha, and 16 lessons. So let's forget about 16 lessons. In 1 bigha, 1 katha, you'll be near your person, where your residence and shops will be there. So even
if
if
your lordship observes that way, then it is all right. Well, leaving aside the residence and the shop, that difference of land can be made into two halves and given to them one half.
no, in one hand, you are saying that 190 and 191
Yes, ma'am.
covers your land, sorry, residence as well as your shop, some of
Yeah,
the
yes,
shop.
ma'am. Yes, ma'am.
Then what is your problem? I don't know.
No, that is
So
all right.
you are saying that no shops can be given, what kind of thing he is saying?
No. That submission was, if your lordship observes like that, it is all right. 190 and 191 will remain with me. Rest given to them in C schedule and B schedule divided into two equal halves. That is all right. Then we don't have any problem.
We will make the observation.
Yes.
We cannot direct the court
Yes,
to pass
yes,
the decree.
definitely.
That observation may be made. Your submission and agreeable to that observation can be made.
Definitely.
That's what I'm saying.
Yes, we'll get another opportunity there.
Yes, obviously.
Even
obviously.
with
And see, your brother, so make some
Yes.
also. Then what? It will be possible. Okay, we'll pass the decree.
It is actually lawyers, my lord, who have to convince, my lord, their respective clients.
My lord, just one thing, because at last they have brought an instruction that none of their shops should be touched.
No. I have clarified that if that difference of land, if it is again divided into two, that 14 or 15 lakhs or whatever, then it will may cover our residential house or that shop. That is why, my lord, your
No.
lordship will pass this observation, and if it works out fine, then is all. Yes.
Oh, okay, then in that case,
Obliged.
Even then, they are getting the rest of the C schedule and 1 bigha, 1 katha, 1 lacha, they are getting.
yes.
Yes.
So where are you now? Now you are staying in B schedule land,
Yes. In
or
B
you
schedule.
else you are saying somewhere else
No, B schedule.
with the agricultural land and all you
It
are
is-
saying B schedule land.
There, yes. So it's
Your houses are also constructed.
Katsa, it is Katsa.
Or
It is,
Katsa house.
yes. So our financial position is much poorer than them actually. Because the rent and
they are
everything,
very rich.
Mesne profit is also there. For rent, they are collecting for so long. We are not going into those aspects. They are getting rent also. We also don't want to equalize on the rent and all. On rent, they are getting benefit of those shops also. It's not that they are not getting any benefit. Anyway.
Okay, then you will get an opportunity of this.
Yes.
Main purpose is to remand back so that the proper decree can be executed.
My lord, one last.
Yes.
My lord, what has happened? We had examined 5 witnesses in this case. My lord, let us hope it will not go to that extent in the court below. My lord.
Hopefully, we are not.
Because some of them have died, and some of them, in the meantime, may have turned hostile. So, in that case, my lord, we will make a prayer for liberty to bring in new witnesses.
Then that liberty should be given to me as well.
Yeah, definitely. They were given opportunity that this cross
Otherwise, how will you?
Yes.
Okay.
Much of that.